When can terms be implied in contracts? There are five main reasons where a court would deem it plausible to have these terms inserted into contracts, even though they haven't been expressly made. And in this video, we're going to have a look at these five main areas. So, first area, past dealings. Depends on the history of the parties. If the parties had dealt with each other before, depending on the sort of contract that they had before, if terms were mentioned, certain terms were mentioned in previous contracts, then the court would deem it suitable to insert, certain terms so that they are in alignment with previous dealings. Now, an authority case is the one that you see in front of you. It's basically regarding the sale of timber, and the court in this instance it found that when it came to the specifications of timber and the delivery, the certain terms had to be implied in the contract. Second area is custom or trade usage. So in a particular industry, so we're talking about construction industry, if it's custom, so if it's known custom that certain terms need to be mentioned in contracts, then the court would insert these terms into the contracts. Again, the previous case that we had highlights this because for the purposes of timber delivery, it was a custom and within that certain industry to have particular terms, and that's what the court said that should have been applied in the first instance, and that's why they implied terms into the contract. The third area is implied in fact. So you can think of this as the court trying to give business efficacy, so trying to make the dealing more efficient, or efficient, I should say, not more efficient. So they look at the specific facts, and if it's obvious to a reasonable person that at the time of making the contract, the parties intended such terms to be included, but they did not include it, then the court will imply these terms. In terms of the test that the court adopts when it comes to implying terms in fact, this is the authority case, the BP refinery case. A couple of points were mentioned by the court. So in order for the court to imply a term in fact, number one, it has to be reasonable and equitable. So the term has to be reasonable and equitable. It has to be so obvious that it goes without saying. It has to be capable of clear expression, has to be necessary to be included in order to give business efficacy. So without the term, there would be no contract that's possible. And this is when the court would find that it's necessary to include that term, to imply that term. And then finally, the term cannot contradict any express terms that are already present in the contract. Another area is when terms are implied by the common law. So if there are contracts of a particular type, this is where the common law would jump in and say, okay, so given the contract was of that particular type and these certain contract types, you have to imply certain terms in them. This is especially true for reasonably fit for purpose products. So let's say, for example, I desired that I would build a deck, and for that I wanted timber that was water resistant. Now, if the manufacturer lists a product or a timber as being water repellent, water resistant, they have to abide by that description. So the product has to be reasonably fit for that purpose. There is also another term that's commonly implied by the common law is the duty to cooperate. So the parties in the contract, they have to cooperate. A duty to act in good faith, again, is implied in contract. And Renault Constructions is an authority case, a New South Wales case. And then finally, the duty that a professional will exercise reasonable care and skill when performing an obligation. And we usually find, these terms implied in the medical field, so contracts associated with the medical field. And this is a case authority to this finding. Implied by statute, so certain acts of the Parliament, legislation, and we have two examples listed down over here, the Australian Consumer Law and the Sale of Goods Acts. And one common provision that you find in these acts, the goods to correspond with the description. So if you're a supplier for a construction material and you have a description for these materials, a certain description, the materials, they have to correspond to that description. So that's a term that would be implied by statute.